And more suspects or offenders may soon be required to provide their DNA to help in crime investigations. If a proposed bill is passed, there will also be procedures introduced to allow the removal of such information in certain instances. The authorities add that additional safeguards will be in place to protect such data. Sherry Look with this report.
Hair and some fabric. Bits of what was left behind when Tui Atie went missing in 2016 in the Garden Spider Bay murder case. Despite little evidence and no physical body, DNA information eventually led the police to the killer, her boyfriend.
If DNA is identified, then it will then help to maybe affirm that there was contact between a suspect and a victim, or it can affirm that a particular person was in a particular location or in a certain premise. The accuracy of DNA matching is of a very high degree, much higher compared to other forms of evidence, including photo identification.
At the moment, around 60% of crime scene DNA samples collected between 2017 and 2021 remain unmatched. With the proposed bill, the database will be expanded. Currently, law enforcement agencies can only collect DNA and other identifying information like fingerprints and CCTV footage for serious offences that result in a criminal record. These include child abuse, murder, rape or robbery. The proposal is now to include less serious crimes. These carry a prison sentence and are non-compoundable by an authorised person like a public prosecutor. They include stalking, drink driving or obscene acts. The police cannot collect DNA for minor offences like littering, for example. DNA could also be collected from those arrested, detained or served with a restriction order under the Internal Security Act. Volunteers too could opt to provide DNA, regardless of whether they were at the crime scene. They may request to delete the information at any time, and the police must accede to these requests. Additionally, people who have been acquitted or granted a discharge amounting to acquittal may apply to have their data removed under the proposed rules. Police now automatically remove the data of anyone acquitted or discharged. But they could soon keep information relevant to ongoing investigations or the security interests of Singapore. Rejected applicants can appeal to a reviewing tribunal within 30 days. However, the government says new legislative safeguards will protect recorded information. That means everyone using the databases will have to be screened and authorized by the police. All access will be recorded, and a tamper-proof audit trail will help detect any data modification. The use of DNA could be expanded, for example, to identify the dead or those who can't identify themselves.